right, this is the time for the Harlan Fiske Finals Moot Court competition. Where is counsel? Okay, counsel, I assume, Mr. Mead, you'll be arguing for the appellant first.
Your Honors, and may it please the Court, my name is Brett Mead, and I represent Defendant Appellant Jeffrey Green on Issue 1, 666 Misapplication. I'd like to reserve 2 minutes for rebuttal, please.
You may have 2 minutes.
This circuit, and this circuit alone, has expressly and squarely addressed the issue of politically motivated spending decisions in the context of 666 misapplication. In United States v. Thompson, this circuit unequivocally held, quote, the idea that it is a federal crime for any official in state or local government to take account of political considerations when deciding how to spend public money is preposterous.
Isn't that directly contrary to the prior decision in De La Cruz?
Your Honor, actually, it's squarely in line with the precedent in De La Cruz. In that case, on appeal, the issue of politically motivated spending was not actually at issue. The only pertinent issue on appeal in De La Cruz was whether the officials in question had the requisite authority to disperse public money.
Isn't that not true? Because in De La Cruz, we were focused on whether a proper intent existed, which actually rendered the issue of authority irrelevant.
That's absolutely right, Your Honor. But on appeal, the argument was that the post hoc authorization in that case essentially cleansed the illicit concept, the illicit disbursement. But actually, in terms of the pecuniary benefit requirement, which Judge Easterbrook makes clear.
Where does that language come from in your proposed jury instruction, pecuniary benefit? I didn't see any words like that in Thompson.
Certainly, Your Honor. So the words pecuniary benefit do not actually appear in the opinion.
Did you just make that up for purposes of this argument? I mean, it's creative.
So no, Your Honor, I'm not actually that creative. But Judge Easterbrook's language in that case was that where the conduct at issue in Thompson, which is a public official dispersing money in violation of a couple state or local rules to benefit politically or for some political reason, is not a federal crime unless the official is on the take, which is the exact language that Judge Easterbrook used. But further, Judge Easterbrook delineates a series of similarly corrupt acts. He says 666 misapplication is to be read narrowly to theft, extortion, bribery, and similarly corrupt acts. He then delineated 4 similarly corrupt acts, all of which involve a pecuniary benefit to either a public official or a third party. And that is actually squarely.
Haven't other circuits that have looked at our opinion in Thompson said that Judge Easterbrook really didn't decide the outside boundary of what constitutes a similarly corrupt act, but only laid a minimum boundary?
So, Your Honor, the other circuits which have addressed Thompson have most frequently, and actually exclusively as far as I could find, addressed it in the context of what it says about violation of state and local procurement rules. So, for example, the 11th Circuit in Jimenez interpreted it to say that minor violations, minor deviations of state and local rules do not give rise to 666 misapplication on their own.
But this is no minor violation. I mean, here we have government official giving money to his hand-picked organization of his personal choice, and he's getting value to himself. He's having them deliver for him and his party. And that seems to me, if anything, a corrupt act. You're saying that falls outside of the definition of corrupt acts under the statute?
Well, Your Honor, I would say that it falls outside the definition of similarly corrupt acts as Judge Easterbrook delineates those corrupt acts.
But Thompson doesn't narrow De La Cruz, and in De La Cruz we talked about use of funds for political advantage, and that was also criminalized by 666.
Certainly, Your Honor, and I would suggest that that language, that solely for their own personal and political advantage language in De La Cruz should be read as dicta. Because in fact, what happened there was you had officials spending money essentially in a campaign context. They were going door to door, offering public funds to sympathetic voters. They're essentially functioning in the context of campaign workers.
Well, they were doing work to motivate voters to benefit them when the election came around. And here, too, the money is going to motivate voters to benefit the party of the Secretary of State when the election came around. And the distinction you see is?
The distinction I see is that in De La Cruz, the conduct is clearly cognizable as a pecuniary benefit to the officials at issue. So in that case, you have them spending money essentially on a political campaign. Now, don't get me wrong, this is incredibly illicit campaign spending. It's offering pecuniary benefit in the form of driveway paving, pool paving, backyard paving in order to motivate voters. But it's still illicit campaign behavior. A campaign
So
that...
the money's going to other people, though. It's not lining the pocket of the official. And here, and what the official is getting is the political mojo, if you will. And here, too, the official is spending money through this nonprofit to get political mojo at the end of the day. So I guess I'm just trying to figure out, it feels a little bit formalistic, the distinction you're trying to make. I'm trying to see right where you draw that line and whether that's one that seems to accord with the statute.
Certainly, Your Honor, and I agree that line is important. And Dela Cruz is more similar, in fact, to the facts of Geneva, which is the other case in this circuit that's considered politically motivated spending. And in that case, you had officials spending money issuing comp time to employees to work directly on their campaign,
Right,
to
and
call people.
didn't we in Geneva say that an in-kind contribution is equivalent to actually spending money? And your client has a re-election coming up in November 2018. It would seem that the end result of what his plan was to suppress voting in the opposing party would be a benefit to his re-election campaign.
Well, Your Honor, actually, the government nowhere establishes that Jeffrey Green, my client, was actually intending to run for re-election. There's simply no evidence in the record to suggest that he
Well, but
had
viewing the evidence, at least as far as the Rule 29 motion, were to view the evidence in the light most favorable to the government. Is that right?
Certainly, Your Honor.
And can't we reasonably infer that if the re-election were to be conducted in November 2018, that he would be reasonably expected to seek re-election? Isn't that a fair inference from the evidence?
Your Honor, I don't think there's anything in the evidence to suggest that Green had any intent to run. The record is simply devoid of anything from which you can infer that his intent was indeed to run for office again.
What if he, hypothetically, what would be the result if instead of giving a grant or authorizing a grant to the DAP, he had given a grant to the National Party and said, National Party, I want you to go out and educate voters, do whatever you want to promote voter awareness, enhance registration, but I want you to confine your efforts to the National Party and not the future party. Would that be a violation of his statutory authority? And if he did that, would that be akin to the sort of pecuniary benefit, the equivalent that you're hypothesizing?
Your Honor, in your hypothetical, if we're assuming that he's giving this money to the National Party to essentially run political campaigns, then in that case, that would absolutely be a 666 misapplication. It would involve a pecuniary benefit to his party.
Isn't that exactly what happened? On page 33 of the record, Ms. David says that he specifically acknowledged, that Mr. Green specifically acknowledged that it would be confusing and mislead potential voters to include in the promotional information that arrests for drunk driving and possession of marijuana would potentially mislead voters into thinking that they were improperly registered. Isn't that exactly what he did?
Well, Your Honor, I would argue that is actually different in kind from spending money directly on political campaigns. And it speaks to the kind of rationale underlying Thompson, which is that if you allow political benefits at writ large to serve as the foundation for 666 misapplication, then you run into grave issues of line drawing. So in this case, you have Jeffrey Green suggesting, as an elected official, that the gains from removing illegal voters from the rolls outweighed the risks of removing legitimate voters from the rolls. Jeffrey Green's intent was not to deregister legitimate voters. Jeffrey Green's mistake was acknowledging that his efforts at rooting out voter fraud would indeed have some negative externalities.
But we're not the jury. I mean, isn't that what the jury might infer, just as you announce? But the jury could also infer from page 33 of the record that Mr. Green had a dual intent. He had part of his intent was just as you indicate, but part of his intent was to encourage future voters in the future party to deregister under the misimpression that an arrest for possession of marijuana or drug driving would mean that they were committing a crime by registering.
Now, Your Honor, I'm glad you pointed out the dual intent prong, because under the instruction given, the instruction is misapplication has occurred if the official uses money for their own purposes rather than the state's. If we take rather than to mean and not the state's, then a dual intent is not a misapplication under the instruction given. And the record clearly indicates that it was both Jeffrey Green's intent, or perhaps Jeffrey Green simply acknowledged that he intended to benefit politically, and that he also intended to prevent voter fraud.
Counsel, I don't see that from the record. Here, it seems to me that the disbursement served only Green's interests and not the state, because the state's interests in applying for the money from the grant, was to do things to encourage voter registration, not to decrease voter registration by issuing a misleading flyer.
Well, Your Honor, actually, in the language of the Stop Russia Act, one of the prongs that it was to be evaluated under was its efficacy in preventing voter fraud. That was part of the exact rationale for the act. And one of the 4 ways that you're allowed to spend money under the act is for the maintenance of accurate voter rolls.
So you're allowed to spend money under the act to commit voter deception in order to eliminate voter fraud?
Your Honor, the point in his creating voter deception, which the record clearly indicates there was misleading information in these
Clearly,
flyers.
and it's in fact conceded. I mean, your client
Of course.
acknowledges that this happened.
Yes, Your Honor, but the point here is that this state's interest standard that the district court used runs into problems of vagueness and federalism in this case. The state's interest standard...
I had some questions about that. Given the intent aspect, this is a statute that criminalizes intentional misapplication of funds. And when you have an intentional criminal violation, I'm just not sure you have a vagueness problem here.
Certainly, Your Honor, and Thompson acknowledges this point, that you see, in fact, in Thompson, there was clearly an intentional misapplication. There was intent to put money towards a specific contractor for political reasons.
But here, I guess I see this as more of a screw-specific intent, that the jury clearly could have found in this evidence, and I think the instructions guided them toward this notion that here's someone conscious of the unlawfulness of what he's doing it in secret, transparency rules are thrown out the window, the bidding process kicked aside, and all of those aspects really point to a much narrower kind of intent than we even had in Thompson, no?
Well, Your Honor, and again, as Judge Bachrach pointed out, there's a dual intent here. In every instance that the government points to where Jeffrey Green mentions wanting to get future party voters off the rolls, he also mentions his intent to get illegal voters off the rolls.
Remind me what the instructions are on what the jury would do with dual intent, because my understanding was that the case went to the jury as a single intent, unitary intent case. Am I wrong?
Well, so the instruction said if the official uses purposes to serve their own interests rather than the state's. So in this case, you have a case where, and this is really the core of the vagueness problem, because as Judge Thompson recognized, any time a public official makes a spending decision, he's going to make a decision that will benefit him politically. Politicians run on agendas and achievements. They might make spending decisions that they know will help them at a later election. They also might make those decisions knowing that even if it benefits...
But now you're going into a problem I saw with your briefing on this, is that you're talking about political motivation as opposed to actual application of the funds. And this statute is intentional misapplication. So we have to look at the use of the funds, the conduct here, and plus the intent. And you're abstractedly pulling out just the motivation, the political motivation, which I see where you get that from some of the cases. But it's a little abstract when you actually have Congress using words in a statute such as intentionally misapply.
Absolutely, Your Honor. And I can see, and Judge Easterbrook acknowledged this problem, that misapply is an inherently vague term. It's an inherently broad and vague term. Judge Easterbrook invoked the rule of lenity in Thompson, which under settled Seventh Circuit precedent, requires that there be grievous ambiguity in the language and structure of the Act. He noted that misapply is not a defined term. And further, misapplication...
Does Congress really have to define terms that have widespread ordinary meaning?
Absolutely not, Your Honor. And I would point out that Judge Easterbrook is no stranger to plain meaning. And yet he does not cite to the plain meaning...
I don't think Judge Easterbrook is God. And we may think this case was wrongly decided.
Your Honor, I don't mean to imply anything about Judge Easterbrook, other than that I believe that if he had intended to rely on the plain meaning, he would have done so. And
But you've already indicated that Judge Easterbrook in Thompson specifically enunciated the definition of intentionally misapply. So it wasn't as if he read the words out of the statute and said this phrase is so broad that it should be read out of the statute. He enunciated a specific definition, and you quoted it earlier.
Absolutely, Your Honor.
And so why couldn't the jury reasonably conclude that this was an other corrupt act?
Well, Your Honor, that's because the corrupt acts that Judge Easterbrook mentions all involve pecuniary benefit. And that's in line with settled Seventh Circuit precedent. There has never been a Seventh Circuit case where they have upheld a 666 misapplication conviction in the absence of a pecuniary benefit. And
But the very words misapplication of funds, it really, I mean, if I embezzle money from the government fisc and put it in my bank account, that seems less naturally to be seen as a misapplication than just what we have here, which is taking government funds meant for A and putting them to some other use, applying them. So it has in fact, a non-pecuniary gain to the individual, I think, core meaning, misapplication, does it not?
I think that's right, Your Honor. But I would suggest that what Judge Easterbrook was implying is that kind of misapplication, taking money for one purpose and putting it towards another governmental purpose that an elected official in their capacity believes to be a legitimate state interest, that is a civil sin if it's a sin at all. Judge Easterbrook is suggesting that that does not rise to the level of misapplication. Rather, if you look at the Act as a whole, 666 outlaws embezzling, stealing, obtaining by fraud, or without authority converting. All of these crimes involve pecuniary benefit to defendants. Judge Easterbrook's outlining of the corrupt acts, and indeed the 4 corrupt acts he mentions, involve that same kind of pecuniary benefit.
Can I ask you, before your time's up, one question about your proposed instruction? Your proposed instruction would allow spending for political reasons, but only if the spending was, quote, otherwise legitimate. Was the spending on a misleading flyer a legitimate expense?
Your Honor,
Is that what you're arguing, that you would prevail under your own proposed instruction?
Your Honor, I would argue that it's legitimate under the understanding laid out in Thompson, which is that the government got what it contracted for. The understanding
Didn't the government want a clean election and robust registration, and is that what it was getting?
So, Your Honor, the issue is not, as Thompson saw it, is not with the quality of the end product. The issue is whether the government disperses funds for one thing and gets that thing, and they're not getting it at a reduced price or at a higher price for shoddy goods, for example. Your Honor, I see that I'm out of time. Do you mind if I finish answering the question?
Of course you can finish the question.
So the point is not that, the point of Thompson is not to scrutinize whether the government got the best possible product, but rather to say that the government money went towards the purpose for which it was designated. In this case, it was a flyer campaign, and it got a flyer campaign. It would be just the same as if the government was buying air conditioners and got shoddy air conditioners. That wouldn't be misapplication. Thank you, Your Honors.
All right, thank you very much, Mr. Mead. All right, Ms. Hush. Oh, I'm sorry. No, you're Ms. Hush, right?
Yes, ma'am.
Okay, thank you.
Good afternoon, and may it please the Court. My name is Emily Hush, appearing on behalf of the United States. There are 3 reasons why this Court should affirm the District Court's denial of appellant's motion for judgment of acquittal and uphold his conviction for the misapplication of funds under 18 U.S.C. 666, the theft and bribery statute. First, the jury instructions correctly defined misapplication according to its plain meaning, and that definition is corroborated by precedent and congressional intent. Second, the instructions do not raise constitutional vagueness concerns under Skilling v. United States. And finally, the evidence is sufficient to convict on the basis of the instruction given. Now, first, the jury instructions correctly defined misapply. Jury instructions are reviewed de novo, and this court held in Hernandez that instructions need not be perfect, so long as they fairly and accurately inform the jury about the law. These instructions met that standard and were therefore not in error. The instructions defined misapplication as the spending of public funds for personal use without legal authority or for
What
purpose.
personal benefit? I mean, did Mr. Green actually get any personal benefit?
Yes, Your Honor. Personal use is best understood in this context within the aegis of agency law, because one of the elements of the crime is that appellant was an agent of the state. Now, under Section 8.01 of the Third Restatement, we know that agency law imposes a duty of loyalty on the agent. Thus, personal use is when the agent takes advantage of the agency relationship for his own interest rather than the interest of the state. This is corroborated by Comment B of that section, which requires the agent to subjugate his interests to those of the state.
But that's not.
I was just going to follow up that on this record, though, did he actually get anything in his own interest?
Your Honor, even if appellant was not going to run for re-election in his individual capacity, which he did not deny when he was asked a question getting to that in his testimony, he was still using state funds that had been earmarked for separate purposes for the purpose of ensuring that the National Party would have a better chance of success at the elections this year. As a member of the National Party, that constituted a personal benefit to himself.
Ms. Hush, what? Oh, I'm sorry. You had a question pending. Go right ahead.
Sorry. I was just going to ask you, but didn't Thompson specifically say that the idea that a public official would take account of political considerations and that could criminalize his decision is preposterous?
Your Honor, this case is in line with Thompson because it does not criminalize political spending alone. Rather, the jury must also have found that appellant had no legal authority for this political spending. And indeed, he did not.
Didn't he have full discretionary authority to figure out how to administer this grant?
No, Your Honor. The appellant himself admitted at page 57 of the record that his discretion was limited, and several provisions of the Stop Russia Act would have prohibited this spending, both for the way that it was executed and for the reasons for which it was executed. Section 2512 D4A of the Stop Russia Act provided that the funds distributed under this program had to be allocated in accordance with, quote, specified terms made publicly available. That means that appellant had to either comply with the public bidding procedure he himself set up or set up some other public procedure.
Well, Ms. David did submit a bid.
Your Honor, appellant instructed DAP to submit a bare-bones proposal which did not contain the information required for evaluating the bids under the bid call, and he instructed the committee not to evaluate that bid. And
well, where is that in 20512? Where is that in the statute that the Secretary of State can't instruct the authority on which of the bid, which bid to accept?
Well, Your Honor, because he instructed the committee not to evaluate the contract at all, it was not allocated in accordance with public terms. This was a transparency
Although
violation.
a narrower reading of public terms might be that the terms of eligibility, what are we looking for? We're looking for contractors to do various things to, make our voting system more robust. That was made public, and people who wanted that money came forward.
However, Your Honor, we must also look to the words in accordance with, and this bid was not given in accordance with those public terms. We may have known what they were because the bid call was public, but we have no idea, or the public has no idea whether DAP met them, and we know from the record that DAP did in fact not met them. DAP had no experience in this regard, and that was one of the terms according to which these bids were going to be evaluated.
Weren't these just minor deviations from the statutory regulations that we haven't held were really cognizable under 666?
Your Honor, transparency is at the very core of preventing corruption in this nation. So violations of this kind of transparency requirement in a governing federal statute are not minor or immaterial. And in fact, that's one of the things that differentiates Thompson.
Was there any showing in the record that DAP was not going to be capable of doing voter registration properly or acting consistent with the act?
Well, Your Honor, that's what the transparency requirements are there for. And had the committee gone through the proper channels to give them this contract. They may very well have been a company that could handle this contract in a lawful way. However, appellant's interference with that process not only violated the federal statute, it led him to design mailers that were designed to intimidate and trick eligible voters into deregistering from the rolls. He manufactured the entire scheme.
What's your response to Mr. Mead's point about dual intent? The notion that it's supposed to benefit the individual and not rather than the state. So that if we find that there's actually a mixed motive, that we would have to vacate the conviction.
Well, Your Honor, if appellant had mixed motives, he could still have been convicted had the jury found that the state did not receive what it paid for. So if we look at the elements of the crime as explained in the jury instruction, he must have used them for a purpose that served his interests rather than the state, and that winking at the rules is okay as long as the state receives what it paid for. And in a situation where he's trying to serve the state's interests as well as his own at the same time, there's bound to be situations where the state really is not getting what it paid for. It's losing out overall because appellant's own interests are overcoming his ability to serve his state. There are situations in which you cannot serve two masters. Thus, appellant could not use this money to prevent eligible voters from deregistering in a deceptive scheme and at the same time be serving the state's interests in voter registration.
I think you've really effectively focused on the process and the lack of transparency. I'd like you to focus a little bit on the intent, and what, in your view, is the best evidence that Mr. Green actually had the unlawful intent to misapply the funds that the criminal law requires?
Your Honor, there are two sources that specifically show appellant's intent in the record. First, pages 31 to 33 of the record show that appellant was intentionally targeting future party voters with criminal records. Ms. David confessed to that intent, and appellant told Ms. David that people with criminal records wouldn't know whether their conviction had resulted in the loss of their right to vote, and therefore they designed the mailers to deceive these voters. He demanded harsher...
Isn't the record, it's far from clear, I think, as to how much input Mr. Green had and how much input Ms. David had.
Well, Ms. David did testify that Mr. Green was the one instructing her in these matters, that he was the one who wanted harsher language. He was the one that wanted more prominent specifics about punishment. And in the wire transcript...
But the flyer specifically said that DAP is solely responsible for the content. What are we to do with that evidence?
Well, Your Honor, the mailer also held the state seal, and the jury found by convicting appellant that that was not enough. That disclaimer was not enough to show that appellant's intent was not behind this mailer. He was involved in the process from beginning to end. He told Ms. David not to tell anyone what they were doing. In the wire transcript, he said to her, "You can't have lost sight of our goals. It'll be weeks before we know how many future party voters come off the rolls. Wait until the next election."
But his position, or at least counsel's position, is that they're trying to take people off the rolls who really shouldn't be there. And so that alone, without more, doesn't necessarily tie you, secure the finding of improper intent. Do we have a jury instruction, a Screws-type jury instruction, that they have to have a specific intent to deprive a person of a federal right? Is that one of the jury instructions here, so that we can be confident that that's what the jury found?
Your Honor, the jury instruction does not specifically address intent, although it is one of the elements of the crime in the statute, and so the jury would have been informed of that content in the statute. It's important also to note in the wire transcript, appellant had also used the language of a cover-up when he said, "I told you from the beginning that this couldn't trace back to me. I need to steer clear of this. You need to keep my name out of this, and if you tell anyone about my involvement, I won't be able to help you."
That's very tough in a political context. There are a lot of things that fall far short of criminal that, for political reasons, political actors don't want to be associated with. So I think that's a very tricky argument here.
Well, Your Honor, the jury did not find appellant's testimony as to his intent of preventing voter fraud credible, and under United States v. Moore, this court does not question the jury's credibility assessments absent extraordinary circumstances.
So can I go back to, do we have to overrule, or take on banc our precedent in Thompson in order to rule for your client?
Not at all, Your Honor. Thompson did not explicitly set the scope of misapplication. What Thompson said was, winking at the rules to help someone deserving but barely over the eligibility threshold is not a crime as long as the state gets what it paid for. But it did not set the outer limits of misapplication, and it did not say that misapplication is not in accord with its plain meaning. Thompson simply said that the statute covers theft, extortion, bribery, and similarly corrupt acts, and the plain meaning of misapplication falls squarely within that definition.
But he said that but the court said that in the context also of saying that intentional misapplication under 666 requires a finding of a government loss and a pecuniary benefit to the defendant.
Your Honor, there was both loss and benefit in this case.
Pecuniary benefit?
Pecuniary benefit, albeit indirectly, Your Honor, because appellant was using DAP, funding their activities to prepare the re-election campaign of the National Party.
Where in the record is there any evidence that he was going to seek re-election?
Not necessarily his own re-election, Your Honor, but the National Party would have been putting a candidate up in this district, and he was preparing the ground for them by getting future party voters off the rolls. And
that's a political benefit. That's not in other words, if there are other National Party candidates that are going to win, how would he derive a pecuniary benefit?
Well, Your Honor, there's no evidence that Thompson did limit the statute to pecuniary benefits, and that would not be in accord with the text of the statute. Section 666A1A of the statute as a whole is dedicated to theft-related crimes which are not done in return for pecuniary kickbacks. So to limit the statute to pecuniary kickbacks would leave that entire section without independent meaning in violation of the rule against surplusage. And that also would not be in line with Congress's intent in passing this statute. The Supreme Court explained in Fisher v. United States that Congress passed this statute in order to create new offenses and increase the government's power to prosecute these kinds of crimes, and that the statute is expansive as to the conduct forbidden. So it should not be narrowed to a definition that misapplication has never been narrowed before to bribes and kickbacks. It's always been used according to its plain meaning. Congress and federal agencies use this word over 120 times in statutes and rules. They defined it 3 times, and each time it was defined in accordance with its plain meaning as some kind of unauthorized spending. The plain meaning of misapplication, according to Black's Law Dictionary, is the illegal, wrongful, or corrupt use or application of funds. And Merriam-Webster's defines it as spending of public funds without proper authority. And the jury instructions adequately conveyed this meaning when they said that it's about personal use without legal authority, or putting the state's interests after the interests of its agent. Thus, the plain meaning of misapplication is in accordance with both Thompson and congressional intent, and the plain meaning of misapplication. And in AT&T, the Supreme Court held that we presume that terms that are not defined in the statute take their plain meaning. And in Caminetti, it says that we presume that the statutory text takes its ordinary and usual sense.
Well, counsel, I put it just a slightly different way. Assuming that this flyer, in fact, had some people who are actually felons who were not qualified to register or vote, deregister, didn't the state get something that it paid for?
Your Honor, it may have received incidental benefits in that regard, but the state was not seeking the deregistration in the contracts that it was pursuing. Although election security is a permissible use under the Act, the state set up 2 programs. One was for increasing electoral confidence in the voting process, and the other was for voter registration. So the state, according to the terms of its own bid call, was not seeking to prevent voter fraud by intimidating people into deregistering from the rolls, even if they were in fact ineligible. And you cannot justify those kinds of incidental benefits by the deliberate misapplication that appellant did by actually tricking eligible voters into deregistering. And by using the terms marijuana possession and drunk driving, he was, in fact, targeting people who had been convicted of misdemeanors, because those crimes are almost always misdemeanors. So there's no evidence that the appellant was trying to only target felons. Had he been doing so, he wouldn't have deliberately used misleading language, as he himself confessed.
And if the jury instructions are erroneous here, overbroad, we just have to throw out the conviction.
No, Your Honor. If the jury instructions have a prejudicial error, retrial is the proper remedy, because the evidence is sufficient to convict even on the basis of appellant's own instruction. Appellant's instruction had 3 definitions of misapplication. First, it's defined as personal use without legal authority, which was in the given instruction in which we have already seen he satisfies. Second, it provided that misapplication is not spending for political purposes as long as that spending is otherwise legitimate. However, appellant's spending was not otherwise legitimate. It violated the transparency provisions of the Stop Russia Act and also the provisions of the Stop Russia Act which set out the purposes for which money can be spent. Because Section D4A of the Act said that none of the money was to be spent to prevent otherwise lawfully registered voters from voting. Third,
But there was before you get to the third one, isn't that argument inconsistent with Thompson again? Because in Thompson, there was a deviation from the state protocol. The lowest, the bidder that should have gotten the contract didn't ultimately get the contract. They were forced into a runoff, which our court held was a deviation from the state requirement.
Your Honor, Thompson was about a minor deviation from state administrative procedure. As it later clarified in the Lupton case, it said, we overturned Thompson's conviction because the, quote, the proof at trial demonstrated at worst minor deviations from Wisconsin's administrative procedure. This is not a case about minor deviations from state administrative procedure. This is about deviations from a federal statute, intentional deviations, intentional violations of a federal statute. In addition, in the Thompson case, the court found that she had the authority to trigger the runoff, and she was doing so to get a local contractor at the lowest price, which was what the state wanted. In this case, we see that appellant did not have the authority to ignore the bidding procedure entirely.
But he could have changed the rules entirely.
He could have, Your Honor, had he still allocated the funds in accordance with public terms. That is what he had to do. He could not give DAP a contract in accordance with private, individualized terms because that wasn't transparent. And unfortunately, that's what the appellant did.
How do we differentiate between a minor and a major deviation of state law?
Your Honor, we don't need to differentiate between those two standards here because a federal governing statute told appellant what he needed to do. In Thompson, there was no federal governing statute. And so her minor deviations, her bureaucratic errors, should not have been criminalized. Like the court said, it was at worst a civil sin. No one should be criminalized for that kind of activity. But here, appellant has deliberately violated a federal statute that instructed him to be transparent about the way that he was spending money. And that's what misapplication is about. It's illegal because all you have to do is comply with the law. That's the least that we expect of our state officials. Now, coming to the third definition of misapplication in the appellant's own instruction. It said misapplication is not spending that does not occur if all the spending occurs without political considerations. Now, what that's getting at is purely political spending. Appellant's spending was not purely political because had he refrained from imposing his agenda on the committee would have spent the same amount of money, but they would not have taken into consideration his political motives, and they would have done so in a lawful way and for lawful reasons, observing the requirements of the Stop Russia Act. Now, because the evidence was sufficient to convict...
Now, explain that again. I'm not sure that I followed why that makes it not political.
Because the committee would not have been targeting future party voters with criminal records. The committee would have looked at the public terms. They would have looked at DAP's experience. They would have looked at the content of their project and how it was going to help the state. And then they would have said, okay, this looks like DAP should get a contract, and they would have allocated the money. That would have respected all the provisions of the Stop Russia Act. So it would not have been political spending in the sense that appellant was using it. Now, because the evidence was sufficient to convict, double jeopardy would not prevent a retrial, and therefore the indictment should not be dismissed even if this court finds that there was a prejudicial error in the jury instructions. I do briefly want to address the vagueness concerns in my remaining 30 seconds. Under the first prong of skilling the United States, the statute must simply be sufficiently definite that ordinary people can understand what conduct was prohibited. And Kayishian explained that that just means that people will not be forced to guess what a word means. And no one is forced to guess what misapplication means because it's been consistently used in precedent, statutes, rules, and ordinary everyday use according to its plain meaning, which simply means the wrongful, illegal use of public funds. Thank you.
Thank you very much, counsel. Mr. Mead, I believe you have 2 minutes.
Thank you, Your Honors. In their oral argument, the government suggested that somehow that the other prongs of 666 misapplication, or the other prongs preceding misapplication, do not involve pecuniary benefits. I would point out that theft and embezzlement are quintessential cases of pecuniary benefit. They involve stealing money. I would further point out that the congressional intent behind Section 666 is incredibly brief but unusually clear. In the Senate record, the Senate said that 666 was passed, quote, to protect the integrity of the vast sums of money distributed through federal programs from theft, fraud, and undue influence by bribery. It doesn't suggest to protect it from misapplication or for payment from
Mr. Mead, what about your opponent's focus on the transparency and on the process and sort of almost as an independent ground for the violation here, that they're just, your client stumbled there?
Your Honor, I would suggest that that is where Thompson is perhaps at its most unequivocal, where, again, violations of transparency, of minor deviations from public bidding procedures are not federal crimes. And this goes to the core of Judge Easterbrook's issue in Thompson, which is that, if you open up political benefits, then you turn the Seventh Circuit into a clearinghouse for state and local spending decisions. And that is exactly what he was warning against. Now, the government suggests that when public officials serve two masters, there are going to be inherent problems that should become federal crimes. But it's an unfortunate reality of popular politics that politicians are inherently going to serve two masters. Imagine the situation where a politician, quote, caves to political pressure. It's often the goal of activists and protesters to put political pressure on public officials. Their aim is not to persuade, but to make spending or decision-making in a certain area toxic. If you had incriminating emails from a public official saying, I don't think this spending decision is in the state interest, but I'm going to get killed at midterms if I don't spend this money this way, if they cave in that case, is that a federal crime? Thank you, Your Honors.
All right, thank you, counsel. All right, we'll next hear from Ms. Beck.
Good evening, Your Honors, and may it please the Court. My name is Lauren Beck, and I represent the appellant, Mr. Jeffrey Green. Today, I'll be addressing the issues on appeal arising under Title 18, Section 241, and Section 242. I'd like to reserve 2 minutes for rebuttal.
You may do so.
Now, we're here today because the government would have this court perform the unusual act of stretching these criminal statutes to reach conduct that has not been established by prior precedent and that Congress has not sanctioned. Ultimately, this court should find that Sections 241 and 242 are not the appropriate vehicles for addressing appellant's alleged conduct in this case. Now, I'll first argue that the district court erred in its jury instruction, and then I'll move on to address the sufficiency of the evidence. First, this court should find that the district court erred when it instructed the jury that the right to vote includes the right to be free from illegitimate intentional government interference.
Ms. Beck, it must be that it violates 241 and or 242 to falsely tell people that they have to, for example, pass a literacy test or own property or pay a poll tax in order to vote in the United States. You're not telling me that those kinds of obstacles, because they aren't actually standing in front of a poll and preventing someone from entering, that those don't violate 241 and 242?
To the contrary, Your Honor, that really goes to the crux of this case, which is that appellant's conduct might be construed as a crime here, but they are not crimes under federal statutes 241 and 242 for several reasons. One, the Congress has communicated that behaviors akin to intentional government interference or dissemination of misleading information is not properly prosecutable under these statutes. In fact, the authority which the government now asks from this court for its prosecuting attorneys is authority which Congress has deliberately withheld. Sections 241 and 242 were originally a part of the Act of 1870, and while these statutes have survived mostly in their original forms, many sections of that act have since been repealed.
Well, precisely, and the original intent of these laws was aimed at just the kind of conduct that I was outlining, and I don't see why this isn't just the modern-day equivalent of that.
The reason why it's not, Your Honor, is because they have repealed sections that squarely address appellant's conduct in this case. Crucially, Congress repealed Section 5506, which penalized any behavior that rose to the level of hindrance, delay, or obstruction with any citizen exercising their right to vote, and this was punishable by up to 1 year's imprisonment. Clearly, then, Congress did, at one point, intend to punish these less egregious and perhaps more indirect methods of interference with the right to vote, while still sanctioning prosecution for more egregious methods rising to the level of intimidation, threats, injury, or oppression. As
But
the
isn't
language
that exactly what we have here? I mean, there was a flyer distributed that was designed to intimidate qualified voters from actually participating in the election.
Your Honor, to the extent that the government now attempts to characterize appellant's actions as intimidation, he had the right to have that charged in his indictment and that specific instruction to be given to the district court. The first time that intimidation has ever been mentioned in this case is on appeal in the government's brief, where they now refer to intimidation over 15 times. And
Well, I think the document itself, the mailing, is fairly characterized as an act of intimidation. That was in the record from the beginning.
That may be the case, Your Honor, but if the government would like to proceed on that theory, they have to go back and retry appellant on that theory, because what was specified in the indictment was the specific method of distributing misinformation intended to deceive.
Well, how does, I don't understand that. How does intimidation differ from illegitimate intentional interference?
The broad umbrella of illegitimate government interference as specified by the district court would arguably include intimidation or voter deception, but that is precisely the problem, is this broad umbrella of illegitimate government interference.
But if he's engaged in intimidation, he's engaged in the core of that broad umbrella, and he certainly would have fair warning that that was illegal.
Your Honors, because the indictment specifically charged misinformation intended to deceive, and that is the defense that appellant prepared for in this case, and it wasn't until he arrived at trial that he first learned that that was no longer the method he was being prosecuted under, but this broader umbrella of illegitimate government interference.
What evidence would he have presented that he did not present, or what evidence did he present that he would have withheld if in the absence of this alleged constructive amendment of the indictment?
Your Honor,
In other words, how was he prejudiced?
he was prejudiced even in the absence of a constructive indictment because the jury instructions were far too broad, because they violated federalism principles, and because fair warning was simply not met in this case. The right to vote has been specifically delineated by the Supreme Court and by this court, and neither has ever identified a right to be free from illegitimate government interference.
What's the federalism problem that you're referring to? 'Cause my understanding is this arises under the spending clause.
Absolutely.
So it's a choice of the state whether to receive this money, no?
The federalism problem in this case is, in light of the opinions of the Supreme Court and this court, every time they have confronted a right to vote case, they have dedicated a part of their opinion to weighing the state's interest in governing its own election procedures with these broad and powerful statutes. For example, in Screws versus United States, the Supreme Court said that violation of local law does not necessarily mean that federal rights have been invaded. And this court said in Bodine versus Elkhart County that the Constitution is not an election fraud statute. So clearly, this is an issue that courts weigh in deciding whether these...
But the difference of Screws and the difference of the other cases that you cited is, unlike those cases, here we have a state official who, according to the government's evidence, has intentionally misapplied a federal statute that was enacted under the spending power. And I don't think that was the case in Screws, was it?
No, Your Honor. The case in Screws actually didn't implicate the right to vote. However, in this case, under Sections 241 and 242, it's not the misapplication of the funds that really leads to the specific intent here. It's the behaviors leading up to the creation of the flyer and the dissemination.
Right, so it's the intent to suppress voters and fraudulently doing that by fraudulently inducing them to engage in conduct that actually rendered them no longer eligible to vote. So they're actually inducing them to do something that changes their status as voters. And there's evidence before the jury that that occurred, and that in fact, voters did change their status in response.
But again, Your Honor, that is not the language that was used in the indictment or the jury instruction. Again, it was this broad language of illegitimate government interference. And
Intentional and illegitimate
absolutely,
governmental interference with the constitutionally protected right to vote, right? So if it's intentional, I guess I see you as having quite the uphill battle. I know you have the harder argument here on the law. But when a person is charged with intentionally violating and knowingly violating a constitutional right and is convicted of that, the kind of overbreadth or vagueness that you're talking about, I just don't see how someone in your client's position really has a gripe or has standing to raise that concern.
The reason for the overbreadth and all these issues, despite the fact that the word intent was thrown out in the jury instruction, is under Screws versus United States, there is a two-pronged specific intent inquiry that must be met in order for sections 241 and 242 to remain constitutional. In fact, the Supreme Court has said that this is the constitutional shoal that keeps these statutes from becoming broad liability mechanisms. And in Screws, the court said that the first prong was that a right that's been made definite must be identified. And under the second prong, willful conduct must be aimed at that right. Here, the first prong was never fulfilled, and so fair warning was violated because, as outlined in Supreme Court decisions, the right to vote does not include the right to be free from illegitimate government interference. So saying that behavior was aimed at a broad constitutional right does not fulfill specific intent.
Isn't that specifically what happened in U.S. versus Howard, however?
No, Your Honor. Actually, in United States versus Howard, decided by this court in 1985, this was a scheme by a group of people to falsely register themselves, and they also canvassed neighborhoods and found people who had moved away or died and cast votes in their favor and cast it for the straight Democratic ticket. That was the classic case in which fraudulent behavior is intimately connected to the ballot, and people
Intimately connected to the ballot and intimately connected to the registration process.
True, Your Honor. Both of those things.
So under Howard, you wouldn't quarrel with, would you, with the idea that 241 and 242 were applied to Mr. Green in connection with whatever he did potentially improperly with regard to the registration process?
Yes, and I think that's an important point to clarify, is that there are two separate issues here. One is registration one of the organic processes by which candidates are elected? And we do not contend that it isn't. And the government and appellants seem to be talking past each other a bit to this extent. It may be the case that registration is an organic process by which candidates are elected. However, the method of interference specified, it's never been held that rises to the level of a constitutional violation, and we know.
Well, okay, you lost me there, because 241 and 242 that were applied in Howard, by definition, involved the Constitution, because 241 and 242 only are triggered by a constitutional violation. And there in Howard, we said that 241 and 242 would sustain a conviction under these statutes that by definition incorporate the Constitution.
Absolutely, Your Honor, but in United States versus Howard, false and fraudulent votes were actually cast in an election. And that is the typical kind of voter fraud that both the Supreme Court and the appellate courts have found is intimately connected enough with the ballot to give rise to liability under 241 and 242.
I could see how you could be, so your position is that there was no actual deprivation of the right to vote in this case. But that, even if he were not, even if the government could not charge and convict him under 242, 241 is the conspiracy statute. And you've conceded an agreement, you've conceded what they did, they circulated the flyer. Why isn't 241 satisfied?
Your Honor, under Section 241, the government was required to prove beyond a reasonable doubt that Green entered knowingly into a conspiracy with at least one other person with the intent to aim this conspiracy at lawfully registered voters. And that is the sufficiency issue that we take issue with.
And the evidence that the government would point to is evidence of witnesses who said they actually did deregister under the false understanding that they might be subject to prosecution if they didn't, and on agreement, evidence from Ms. David herself that she agreed with Mr. Green to try to bring this about. So what about that evidence is not sufficient to support both 241 and 242?
Under 241, Your Honor, that evidence certainly goes to the formation of an alleged conspiracy, a partnership, a knowing decision. However, the specific intent, even on the jury instructions given, which we still contend were in error, he had to aim this conspiracy at lawfully registered voters specifically. And the evidence in this regard didn't rise to that level. In fact, Ms. David testified at page 33 of the record that Mr. Green told her that he knew that people would be misled by the crimes of marijuana and drunk driving that were included on the flyer, but that he said that the benefits of deregistration outweighed the risks of getting legitimate voters to deregister.
Well, let's go to page 33. The question is, so the information that says individuals who have been arrested for these minor things should consider whether they have the right to vote and consider whether their registration is legally accurate. Did you and Mr. Green discuss the fact that this would be misleading? Answer, yes. And then the sentence that you're talking about. As I said before, Jeff said the gains outweigh the risk of getting legitimate voters to register. My question to you is this. What is the permissible or a potential gain from misleading registered voters by telling them that if they have been arrested for drunk driving or possession of marijuana, misdemeanors, that is somehow beneficial, that is permissible? He knew, you know, that would not cause someone to be unlawfully registered. So I don't get how that is permissible.
Absolutely, Your Honor. And the argument is not that that was permissible. We agree that this behavior may be construed as a crime under state laws. We specified in our brief, but that does not make it a constitutional violation under 241 and 242. What the flyers demonstrated and what the language of the benefits outweigh the risks demonstrate is that appellant clearly had a reckless disregard for citizens' rights.
I would say more than that based on the evidence, and we do, in reviewing the conviction, have to take the evidence in the light most favorable to the conviction. And we have testimony from Ms. David that said, Jeff said that a lot of people with criminal records wouldn't know differences between being a felon who lost her or his voting rights and an arrested person who never did. That is pretty damning. If a juror hears that and attributes based on that to Mr. Green an intent to go after people who actually had a right to vote, how can that not support the conviction here?
While weighing the credibility of witnesses and the evidence is certainly a matter for the jury, this is precisely what we ask juries to do, because the specific intent standard under these statutes is what keeps them constitutional, they are rigorous and they must be fulfilled both in the jury instructions and in the evidence presented. And what this evidence demonstrated at most was reckless disregard, which again may be a crime under state law, but is not under Section 241 and 242, which requires specific intent aimed at a definite
But that also
cause.
was the jury instruction. And again, I know you've got a tough record here, but the jury instructed that the individual had to be found to have acted knowingly and willfully in subjecting registered voters to the deprivation of their constitutionally protected right to vote, not recklessly, not with gross negligence. So looking at that, don't we have to presume that that was properly found by the jury based on that evidence, and permissibly so?
Not in this case, Your Honor, because as I stated, this specific intent standard is so rigorous that this court should carefully scrutinize the evidence that was presented and whether it truly amounted to specific intent. I'll quickly turn to Section 242, in which the government was required to prove 3 elements beyond a reasonable doubt. That is, specific intent to deprive under color of law. And actual deprivation must have occurred. Here, no actual deprivation occurred because not a single voter was prevented from casting a vote at an election. As this court has said in...
We don't really know the answer to that question, do we? I mean, from the record, we do have Mr. Green talking about future roles are coming in and with some sort of excitement or anticipation, as though he was expecting that to be the result.
That may be the case, but as this court said in Reichenberger versus Drithard, the mere possibility of remote or future injury is not enough under the actual deprivation standard.
So the government should have waited until after the election to prosecute?
The government should have presented a single witness who was actually prevented from voting, or
Well,
they should have.
Mr. I'm sorry, I can't remember the name. Robertson, maybe, he did he deregistered, so that means he couldn't have voted.
Mr. Lewis Richards was.
Okay.
Apologies, Your Honors.
You
I
may
say I'm out of
finish-
time.
you may finish your answer.
Mr. Lewis Richards testified that he was deregistered for a short period of time, but that the next election was over a year away, and that he had not actually been prevented from participating in an election. Moreover, Your Honors, because of this stringent standard for actual deprivation, the government just simply should not have brought a claim under Section 242. Perhaps there was enough evidence to demonstrate conspiracy, but there was not enough evidence to demonstrate actual deprivation.
All right, thank you, counsel. Mr. Juritzma?
Good evening, and may it please the court. My name is Jan Jortsma, appearing on behalf of the United States. This court should uphold the appellant's convictions on counts 2 and 3 for criminal interference with the right to vote. The appellant argues first that the trial court overstated the scope of the right to vote, and that right was therefore not clearly established and overbroad and vague. And second, he argues that the evidence in the record is insufficient to support a conviction on both counts. But this court should reject those challenges for 3 reasons. To begin with, they rely on an overstatement of the standard for clearly establishing a constitutional right that the Supreme Court set out in United States v. Lanier. And under the appropriate standard for clearly establishing a constitutional right, 3 lines of cases: criminal prosecutions under sections 241 and 242, civil actions to enforce the right to vote, and judicial review of legislative impediments to voting all clearly establish the scope of the right to vote as it appeared in that trial court instruction.
Well, didn't Lanier specifically say that the statute has to be, cannot be ambiguous, it cannot be vague, and must be fixed by rule or decision, right?
That's true, Your Honor. So the standard Lanier set out was that a reasonable official must fairly understand the contours of the right. The crucial element that they rejected is fundamental factual similarity. They pointed out that in certain contexts, even general statements of law can clearly establish a constitutional right when those statements are sufficiently clear about its scope and application.
So what precedents do we have in our circuit or in the Supreme Court that have specifically extended a criminal conviction under 241 or 242 to a situation where someone is potentially impeding someone from registering or encouraging someone to deregister? What case would have clearly established that extension of 241 or 242?
Your Honor, specifically in the criminal context, United States v. Mosley at the Supreme Court, and most particularly United States v. Saylor at the Supreme Court, would clearly establish the scope of this right. So Mosley rejected the notion that you need physical or temporal connection to the ballot. It upheld a conviction for stuffing the ballot box, even though no individual was actually prevented from voting. And Saylor is particularly relevant here because the court rejected just the argument the appellant is making here. So in United States v. Saylor, the prosecution was for fraudulently tabulating the results of an election.
Well, both of those, both Mosley and Saylor were talking about the actual vote, casting the actual ballot. My question to you is, in what case, and I don't think Mosley or Saylor addressed this, extend 241 or 242 to registration as opposed to something involving tabulation of votes?
Your Honor, in the criminal context, United States v. Howard would be the case that brings registration in by saying that interference with the right to vote, extending back to registration, is included in that right. But
in Howard, the difference is there was language about registration, but these were false, fabricating 22 people that were registered, and then directing of how those ballots improperly obtained would be cast.
That's true, Your Honor, and it's also true that Howard is probably the high watermark there, specifically in the criminal prosecution sense. But 2 points are important to note from Lanier. The first is that it's rejecting this notion you need fundamental factual similarity. It's rejecting the notion that you need to find specifically the interference in a prior criminal prosecution.
How do you
This is a-
reconcile
this is
that
a-
with Kosminski?
You can go ahead
Your
and
Honor,
answer.
so Kosminski was concerned about the broad scope of the right at issue there, the 13th Amendment protection against forced servitude. And it was suggesting that the right at issue there wasn't clearly established even by general statements of law. It suggested that the fact that there was some element of coercion in a employment situation almost included every single employment
But
context.
don't we have a very parallel issue here? Just as in employment, legitimately supervisors goad people into doing things they don't really want to do and overcome their will to, stay home and eat bonbons. Here we have the countervailing interest, the First Amendment interest in speech. Now, are you saying, under your interpretation, if I were to publicly say, boycott the polls, the United States democratic system is broken, don't go vote because it won't do you any good, that I could be criminally prosecuted for that, for interfering with voter registration?
Not at all, Your Honor. And that goes to the second line of cases that clearly establish the scope of the right here, which are those civil cases to enforce the right to vote. So in Rudisill v. Flynn, this court addressed just that question. And it drew the line at the free exercise of the right to vote, as the trial court put it here. It drew the line between the mechanics of voting and statements that would implicate the First
I
Amendment.
was interested in that aspect of your brief. How did you come to distinguish Rudisill that way? What do you see in Rudisill that distinguishes it into the compartment of mechanics versus the process itself?
Well, there's 3 points there, Your Honor. To begin with, it's the way that this court has interpreted Rudisill going forward. So in Parra v. Neal, this court used the language of the organic processes of the election, of the voting process, and it cited back to Rudisill for that characterization. So that's indicating that Rudisill was intended to relate to those processes. It's also clear because from the holding in Rudisill itself. Rudisill is trying to distinguish misrepresentations on the merits of a political proposal, misrepresentations about the need for and cost of a sewage project, from the misrepresentations that this court held stated a constitutional violation in Smith v. Cherry.
So the First Amendment tolerates a certain amount of deception in the campaign around, but it doesn't tolerate a deception in the mechanics, like the step of registering versus actually going to the polls. And those steps, if there was interference at any one of those steps, that would be a violation, in your view.
That's correct, Your Honor. So Rudisill says that those misrepresentations about the merits of the political proposal are not constitutional violations. And it distinguished Smith v. Cherry using 3 factors that get to that substance procedure distinction. Those factors are the intimate connection to the ballot. And because it couldn't be the case that simply putting misrepresentations on the blurb about this sewage proposal would have turned them into some kind of constitutional problem, because the court is talking about a First Amendment concern, that intimate connection to the ballot must be a connection to the voting process. Second, it looked to whether voters were deceived about the impact of their vote, and it looked to whether one set of voters were advantaged over another. All those go to a procedural fairness element.
What if I were to say, don't vote for the Nation Party candidates, they are backed by Satan? Is that a procedural, or is that political debate?
Your Honor, that would be on the merits, because it's discussing the character of the National Party. A procedural misrepresentation is just one that meets those 3 factors in Rudisill. So that doesn't, it favors one group of voters over
Don't
another.
register to vote. When the government knows your name, they'll be more likely to audit your taxes.
That would still probably be, it's a political opinion.
That's probably
but
truthful.
I'm sorry. Well, if you say so, Your Honor.
It's getting very close to this, to the facts here, no?
But the difference is the other language in the instruction, the language of intentionality, and the fact that we here are nowhere close to the line. Certainly, procedure, in some sense, everything has some relation to your ability to cast a ballot, but voter registration is a universal, essential legal prerequisite. To the extent that something is clearly a procedural requirement from voting, it's voter registration. And the second point is that the conduct needs to be intentional. So it's not just that it's a good faith belief that voting isn't the right way to affect change that causes a negative effect on turnout. It's an intentional targeting of those individuals.
So under your theory, if I were actually trying to keep people in an opposing party from registering, and I knowingly, falsely told them, don't register because, in fact, you're more likely to get audited by the IRS, that would, in your view, fall within the statute. If I had the requisite intent and I'm trying to basically threaten them, you're going to be in trouble if this happens.
Well, I mean, putting it that way, it would depend on the statutory language and the jury determination. So there you would probably meet intimidation, and then it would be a jury question about whether individuals found that credible and whether it really put enough pressure to cause an actual deprivation. Now,
let me just ask, so what if the exhortation wasn't, don't vote for them because they're Satan? What if the message is, all right, everybody who belongs to the National Party votes on Tuesday, and everybody who belongs to the future party votes on Wednesday?
Your Honor, that would be a procedural misrepresentation. It could be shown that actually deprived individuals of their ability to register to vote, or in that case, to actually cast a ballot. Again, that would be a jury sufficiency question reviewed under the highly deferential standard in the United States.
Do you have a case like that? A case on point on that?
To my knowledge, I'm not aware of a case addressing deceiving voters about the day that they cast a vote. But we do have cases addressing other types of procedural misrepresentations. So for instance, in Griffin v. Burns, the First Circuit held that deceiving voters, causing them to believe that they were able to vote by absentee ballot, when in fact absentee ballots were not legitimate in that election, was sufficient to state a constitutional injury. And there's other cases that specifically include voter registration within the scope of the right to vote. So for instance, Davis v. Guam from the Ninth Circuit held that interfering with voter registration, preventing an individual from registering for an election that had not been scheduled and may never occur, was sufficient to state a constitutional
But we don't
violation.
have any precedent in our court. You mentioned U.S. versus Howard. Other than Howard, would you agree we don't have any cases in our circuit like Davis versus Guam?
Your Honor, in Edgar v. Acorn, this court held in the context of judicial review of a legislative impediment to voting that registration is, quote, inseparable from election. So there the court was considering whether Illinois had decided not to comply with the Federal Motor Registration Act, which required them to facilitate voter registration at the DMV. And they argued that Congress's power to regulate federal elections did not extend to the power to regulate the state registration requirements. This court held to the contrary. It held that registration was connected to the election process.
What do you make of, I guess it was Ms. Beck's argument that the voters all retained control of their own votes. No votes were blocked. So you really can't, because in effect this scheme worked through the volition of the individual voters, it really wasn't an interference with their voting. They chose to take steps or not.
Your Honor, the operative action here is intimidation. Intimidation met Section 241, and intimidation caused the deprivation under Section 242. In a case where an individual makes a threat, there's always some level of volition on the person who receives the threat. Somebody can call a bluff. If a police officer was standing outside of the polling place telling people, I will arrest you if you walk inside, and some people nonetheless went inside the polling place, that wouldn't take away from the fact that for those people who did in fact get turned away, they were intimidated in violation of Section 241.
Well, you may have intimidation, but there was no actual deprivation under 242 of the right to vote because nobody could have voted.
Well, Your Honor, under the appropriate instruction, what's required is to show intentional, illegitimate interference with the free exercise of the right to vote. Interference with voter registration is interference with the right to vote because of those cases. Edgar v. Acorn in this circuit, Davis v. Guam in the Ninth Circuit, United States v. Wood in the Fifth Circuit, upholding injunctive relief to prevent interference with voter registration.
But still, you don't have any cases in our circuit that have said that either under 1983 or 1985 or 241 or 242, where there was active deployment of efforts to encourage people to deregister or to not register, separated from a denial of the actual casting of a ballot.
That's true, Your Honor. There has not been a case in this circuit addressing the issue of denying purely voter registration.
In that fatal under Lanier.
No, Your Honor, because what Lanier...
Because it has to be clearly established by rule or decision.
That's true, Your Honor, but what Lanier asks is that a reasonable official could fairly understand the contours of the right.
Let me ask, what if we agree with Appellant that this instruction, guarantee of freedom from illegitimate intentional interference, was incorrect because there is no case that really clearly establishes that point? Can you still prevail?
Your Honor, under the appellant's instruction, the appropriate remedy would be retrial because there's still sufficient evidence in the record from which a single reasonable juror could conclude beyond a reasonable doubt that the appellant was guilty, which is the standard under United States v. Huddleston.
Guilty of what, if we were to correct the jury instructions?
Guilty of both 241 and 242. So certainly 241 is the stronger case. We have his wiretap statements on page 73 of the record where he tells Ms. Green to think of their goals, to think of how many future party voters will be coming off the rolls. That's enough to show intent. We have her testimony on pages 31 to 33 indicating there's an agreement, and we have the fact that she testifies that he took an active role in designing this flyer to show he's taking steps to further this conspiracy with the intent of actually preventing future party voters from voting. With Section 242, under the appellate's instruction, it's closer to the line. But there's still sufficient circumstantial evidence from which a jury could conclude that at least one person would actually have lost their capacity to vote and would be unable to vote in the election. So here we would have his statements about his goals, getting future party voters off the rolls, Mr. Richards' representative testimony on behalf of the broad class of victims about the fear and intimidation that he felt when receiving the mailer. We would have the structure of the mailer itself, which targets lawfully registered voters. We would have the expert testimony from Ms. Gold talking about the impact of a misleading campaign like this, talking about the ambiguous impact that the fact that this comes from the government might have, which might mitigate the ability to reach out to the media in order to correct the fraud that was perpetrated against these people. And you have the fact that these are low information voters, so the jury would know that they're the least likely to receive information from the media about the appropriate standard.
And you have Mr. Green's testimony anticipating that when the election happens, there may be great things in store for the National Party, right?
Right, exactly. So all those statements together are sufficient for at least one juror to conclude that somebody has lost their voter registration and will actually be unable to re-register. That's just like prosecutions in the income tax evasion context, where there's a single material fact that the jury needs to infer from circumstantial evidence. The single material fact is the income of the defendant, but the government often has no direct evidence of that. Instead, it presents evidence about lifestyle and expenditures and often statistical evidence, like the expert testimony from Ms. Gold.
But how can there be denial of a right to vote if there had never been an election? There might be an intent there might be a conspiracy under 241, but how could there be under 242 the actual deprivation of a vote if it wasn't even an election?
Well, Your Honor, because of the
Mr. Richards could have re-registered.
And Mr. Richards, in fact, did re-register. But the point is the intimate connection between voter registration and the ability to cast a ballot. Voter registration is an essential, universal legal prerequisite to voting. So if somebody's lost that capacity and will not be able to get it back, will not be able to mitigate the fraud that's been perpetrated against them, then they've lost their right to vote. The inference that the jury would have to make is that at least one individual is not going to be able to mitigate this harm, that they're not going to be able to take that affirmative step because they have insufficient access to the mitigating information. And that's just a prosecution on the basis of circumstantial evidence. And the evidence in the record is at least sufficient to convince one reasonable juror of that fact. But the government doesn't feel we need to address this question because the jury instruction is supported by these three independent lines of cases. In addition to the criminal cases we talked about at the beginning, and Rudisill v. Flynn and Smith v. Cherry from this circuit, you have cases from other circuits. United States v. Wood upholding injunctive relief for interference with voter registration. Smith v. Meese saying that the right to vote includes protections for voter registration. Means v. Wilson saying that destruction of voter registration lists, together with the destruction of some ballots, stated a plausible constitutional violation. Those cases together establish a fairly robust consensus among circuit courts that the right to vote includes protections for the legitimacy of the overall process. It protects voters from illegitimate intentional government interference with the free exercise of that right. And under the standard, the Supreme Court case, Ashcroft v. Al-Kid, even a robust consensus without controlling authority, I'm sorry, see, I'm out of time. May I just finish my sentence? Is sufficient to clearly establish that right. Thank you.
All right. Thank you very much, counsel. Ms. Beck?
May it please the court. Your Honors, one quick point on rebuttal, which is that the government's position suffers from a serious flaw here, which is that their theory of what the right to vote includes presents serious unlimited liability concerns. They attempt to distinguish between what speech could fairly rise to a constitutional level and what could not by creating a distinction between policy and procedure, which is not stated in any case law by this court or the Supreme Court. And in doing so, they ignore the explicit language in Smith versus Cherry, in which this court said—
They have to have some way to distinguish some of these cases, and it seems like that's a pretty appealing way to look at it because you take it outside of the marketplace of ideas and political opinion and you stick it into something very much tethered to the ballot process, which is what we've said you have to do in Rudisill.
Your Honor, the standard laid out in Smith versus Cherry did give a standard for which we decide whether deception rises to the level of a constitutional violation. In Smith versus Cherry, this court said that deception on the face of the ballot fairly implicates the right to vote. And Rudisill tried to distinguish the misinformation in that case from the facts in Smith versus Cherry. And in so distinguishing, they said that the behavior in this case was not intimately connected to the ballot because Smith was on the face.
What's more intimately connected than registration and going to the voting booth?
While the right to vote is a process, obviously, and there's many stages that occur over that, the issue here is that Section 241 does not apply just to the conduct of government officials. In fact, in Griffin versus Breckenridge, the Supreme Court said that Section 241 can reach wholly private conspiracies. If we are going to criminalize speech directed at any constitutional right, this is going to present serious First Amendment concerns as well as serious unlimited liability concerns. So this court should adhere to the standards set out in Smith versus Cherry and find that deception must be intimately connected on the face of the ballot. Thank you.
Thank you very much, counsel. I guess this session of the court is adjourned for now, and we will proceed to deliberation. Ray, good afternoon again. So first of all, I want to say that each of the four oralists was excellent, absolutely terrific arguments, and brief writing. It's such a pleasure to come to Moot Court, where the students are always so much better than 99% of the lawyers I see every day. Each of you did a really fabulous job. It's very, very difficult to choose someone who's the best. But just to point out a few things, Brett Mead, I thought you had really good arguments in response to some of the questions, and in particular, I thought the way you turned Judge Bachrach's dual intent argument around on him was really quite seizing the day. And you made as much use and really excellent use of Thompson as you could. Most impressive to me was your rebuttal. It was very strong. I just wrote down to myself, quick on his feet. Really very quick argument, and you just really tacked into a weakness that had been rendered by the other side. And then Emily Hush, I thought your command of the record and the law was just extraordinary. You had really good arguments on, you kept coming back. Everything that we raised, you turned, but it also was with a sense of really understanding election law and the purposes of it. Ms. Beck, I thought you had the absolute toughest argument. It really, really was. And yet you just hung in there. You were not rattled by a single question, and you were solid and strong. And you also did a great job in your rebuttals. It was very wise of both of you to take your rebuttals. And I thought you kept hitting on a really great distinction between what's a federal constitutional violation versus a violation of which should just be a simple state law. And that was really excellent. And Mr. Jurista, I thought you also, your distinction, as I said, in the oral argument, trying to align the cases was really quite genius. So it was very good.
Before I talk about the four advocates, I do want to make a comment about the group that put together the problem. I think it's those of you in the second row, maybe.
At least one of them, I see.
It was fabulous. You all did.
Who were those people? Can you just let us know?
I think we ought to applaud for all of them. You know, I already bragged on you all at lunch, but I really mean it. I think putting together an evenly divided problem is difficult in itself, and I thought it was really a very well decided, very well constructed issue on all four aspects of it. And I thought it was the bench brief that I know the advocates weren't privy to, but we were, and it was very well done, very well written and analyzed. And I have sort of a broad comment for all four of you. You all are already incredible lawyers. I would expect coming to a school like this with with everything that comes behind, being the best of the best in the moot court competition, that we would see a really top tier arguments, and all four of you really embodied that. One of the most difficult things, I think, for very seasoned lawyers, and it's not, and I don't mean this pejoratively for seasoned lawyers, but it's very difficult when you're anxious to get up there and listen. It's easily said, but it's very difficult to do. And when you are not used to appearing before judges, and you know that all of your families are here and your friends are here, I think that it would be doubly difficult. But you all four of you, really listened very well to the questions, and it was remarkable that you all without exception, answered our questions. And you would be shocked at how often in all three of our courts, lawyers don't necessarily do any of that. And so you're very well, you're way ahead in doing that. And all four of you also segued very well after answering our questions to the points that you all wanted to make. And I truly mean that for all four of you. But you know, you're all obviously winners by making it to the finals of this prestigious competition. So I think all of you, all four of you, should feel very, very proud of yourself. And I do also want to make a comment about your briefs. One of the most important things, I think, for any litigator, whether you're a trial lawyer or an appellate lawyer, is to communicate well, not only orally, but in writing, because so much of your advocacy is going to be in writing. And all of you communicated very well in your briefs. And one of the things that I value a lot, and I'm sure my colleagues do as well, is that it's easily understood. You can't persuade somebody if the judge doesn't understand it, or if the judge has to go back and reread sentences. Or to come to a pronoun and figure out, well, what is the antecedent, and to go back and reread, to figure out what the lawyer is talking about. And all four of you really communicated very clearly what you were trying to say, and so you're way ahead of the game in trying to persuade us because we understood it. And so I think all four of you are already excellent lawyers, and I hope your legal writing professors are in here that can take full credit for how well you've accomplished that. And those are all my comments.
So it's a little bit of a, I don't know, it's sort of a cliche that you come into a competition like this and you say it's a really hard decision. And it was a really hard decision. I kept waiting for you to disqualify yourselves. Get up and, oh no, not another great one. I didn't realize I had to distinguish at that level of granularity, So really, kudos to all of you. Really, really well done. When I was a young lawyer and I argued my first case, which was in the Second Circuit, in the Court of Appeals, I remember thinking, oh my gosh, I've never done this before, and then I thought, no, I have. And the experience that I drew on was my moot court experience. I mean, it's fake, it's pretend, but it's very, very real. So you've done something that really will stand you in good stead. And I have just a few comments for each of you. Brett, you set the bar really, really high. And my notes say clear, calm, responsive. And I really liked, you had a couple of sort of thematic things that really stuck in my mind. One of them was when you talked about politicians running on their own achievements and how, there's a way in which that sort of fit into a core theory for you that I thought was really great. And also the way you dealt with that intent question and why if there were two intents, you win. And how you had the phrase to sort of tie that to. And I was like, oh, I hadn't really focused as much on that until you talked about it. I thought that was really persuasive. But then you had an opponent who got up and persuaded me the other way. Emily Hush, I have notes here, rock solid, like a steel trap. I thought you were really, probably had the most words in your delivery, which was, there were moments when I thought, okay, she's just talking too fast, and that's something people might have told you. You should keep that in mind. But I ended up feeling like, yeah, and she's using her airtime and really getting it out. So, and you had getting what it paid for, and is the government getting what it paid for, and making the argument about where the motives are mixed. That sort of raises a presumption that they're not. And for me, that was helpful, persuasive. I really liked that. Lauren, I actually said from the bench that I thought you had a really hard argument, and you really kept your composure and stuck with it, came back, and maybe a little later than you could have. You pivoted and said, okay, you talked about specific intent. I'm also going to talk about the deprivation. I'm going to talk about undercolor, and sort of move from when we're skewering you and trying to kind of keep you like a bug on the thing that is hard and that you can't, there's a hardness there that isn't your fault, that you were graceful about moving off of that onto some of the other points. So I thought you were very like beyond your years professional in a tough case. And Jan, really, it took me a few minutes to remember. You had this argument that Judge Wardlaw also commented on about making the distinction between the procedural and the sort of more issues advocacy, which I just thought was really creative and impressive, and sort of lawyering at a level of, doing something with the material that is your value added. And I just thought that you pulled that off. It's a little bit, you have to actually teach the bench because it's not in the package that's handed. I mean, it was because it was in your brief, but I thought that was really a very mature kind of advocacy that was really, really quite impressive. I also have to say for all of you that, and I'm guessing that your legal research and writing professors have emphasized this, but you were very good at not always being at one speed in terms of your confidence in your arguments, and sometimes like, well, that would be harder. And I remember, Jan, you did this at one point, okay, the conspiracies, and then on the other, here's my argument. You concede a little bit, but still have confidence. But when the bench is really skeptical, you just seem to, and it's tough because you don't want to overdo it, you don't want to give things away, but to seem to have judgment and be grappling along with the judges. And you already, each of you, have the beginnings of that, which really also makes you seem more trustworthy. And that's one of the things, the non-sort of directly substantive things that demeanor and delivery cue that can actually be quite valuable. So I thought you all did a really, really impressive job. You should feel great.
So with that, we're going to recognize the Student Executive Board. First, the Harlan Fiske co-directors and co-drafters of the problem. Gideon Hanfit. Do you want to see it? And Sam Callahan. Thank you for that. Next, the Executive Director of the Moot Court, Julia Choi. Is she here? Is she here? You stand. What?
She's at the 1L Moot Court.
She's at the 1L.
1L Moot Court.
Oh, okay. All right, Julia, we miss you. Okay, the Foundation Moot Court Program Director, Daniel Rodriguez.
He's probably there too, right?
He's there too. Okay, the Specialized Moot Court Director, Jordan Weatherwax. Is he here? Nope, he's there too. Okay, and then you have a lot going on here. And the bailiff, Stephanie Adam Makos. Next, in recognition of the fact that you are finalists, and that's an amazing achievement, we're going to hand out those certificates. First to Brett Mead.
Congratulations.
Next to Lauren Beck.
Congratulations.
Emily Hush.
Congratulations.
And Jan Garrison. I'm sorry if I mixed it up.
Congratulations.
Next, we are going to present the Greenbaum Best Oral Argument. And again, this was really, really difficult. We just got in the room and said, oh no, what are we going to do? How are we going to do this? But the honor goes to Emily Hush. And our final announcement is the award for the best written brief, which I'm pleased to say goes to Jan Juritsa. So thank you all for a wonderful day. You all did just terrifically. Again, everyone should feel great. And I guess we're going to go take pictures now.